Hello and welcome to The Print. I'm Khadija Khan and today I'm going to be telling you about a recent judgment by the Madras High Court calling money laundering a standalone offence. This means that a probe under the Prevention of Money Laundering Act 2002 can be carried out without registration of any predicate or scheduled offence such as cheating or corruption. We will examine the ruling's meanings, its possible implications, and how it departs from the law laid down by the Supreme Court in its 2022 two-judge bench ruling in Vijay Madan Lal Chaudhary versus Union of India. But first, let's take a look at what the case was about. In this case, a two-judge bench of the Madras High Court was dealing with a petition filed by the Enforcement Directorate challenging a lower court order that accepted a closure report filed by the Tamil Nadu police in a cheating case. The Enforcement Directorate or the ED is a central agency empowered to investigate anti-money laundering allegations under the PMLA. A closure report is filed by the investigating agency before a court to shut a case owing to the lack of evidence. Now, Section 189 of the Bharatiya Nagrik Suraksha Sanhita allows an accused to be released when evidence is insufficient. In this case as well, the Tamil Nadu police filed a closure report with respect to an FIR registered under Section 420 of the Indian Penal Code in November 2022. Now, Section 420 of the Indian Penal Code relates to cheating. The FIR was lodged in the year 2012, which means that the closure report was submitted nearly 10 years later. The case originated from rupees 7.20 crores of unaccounted cash being found at the Chennai residence of Martin's business partners. The partner, Nagarajan, claimed this amount was made up of the sale proceeds of lottery tickets from Kerala and Maharashtra, which were printed in Calcutta and Faridabad by his partners Martin and him. The case witnessed several twists and turns, with the police at one time accusing Martin of producing fabricated documents in the court. Finally, in 2022, it ended in the filing of the closure report, which was accepted by a local court in Alandur in November 2022. Now, as per the law, the ED can initiate investigation under the PMLA only if there is an FIR registered in connection with a predicate or scheduled offence that finds a mention in the anti-money laundering law. These offences can be found across different laws such as the Indian Penal Code, the Explosive Substances Act, the UAPA and the Arms Act, etc. Simply put, a predicate offence is the underlying offence committed to obtain the proceeds of a crime. This means a person can be investigated if he or she is named in an FIR registered under the predicate offence. And since cheating is one such offence, the ED launched its anti-money laundering probe against Nagarajan. However, this inquiry began in 2016, which is nearly 4 years after the Tamil Nadu police registered its FIR. In the said case, the ED chose to challenge the trial court order, accepting the closure report. But what the Madras High Court judgment does is it allows an agency that has no direct involvement in the investigation of the predicate offence to have a say in it. In a way, it has expanded the ED's jurisdiction and given it an upper hand to question a court in case the original prosecuting agency does not demand a review of it before a higher court. Importantly, the judgment comes at a time when the ED has been called out for its arbitrary approach in probing cases and opposing bail applications, saying that the PMLA's object was crystal clear from the day of its inception, which is to protect the economic strength of our great nation and the interests of the common man. The Madras High Court said that laws such as the PMLA must be handled with caution without injuring any vital parts of the Constitution. The court also said that the PMLA's successful functioning rests on the investigating agencies, stating that the state agency had attempted to bury the predicate offence in a suspicious manner and on extraneous considerations which were visible through their actions, like the filing of the closure report. The court directed the ED along with the state investigative agencies to proceed with the case according to the law. It also said that while a complaint under the PMLA is pending, the closure of the predicate offence would result in a miscarriage of justice. Legal experts have also raised concerns on the High Court's findings about the PMLA being a standalone offence. They believe this observation contradicts the Supreme Court's 2022 verdict in the Vijay Madan Lal Chaudhary versus Union of India case, where it held that if a person is finally discharged or acquitted of the scheduled offence, there can be no offence of money laundering against him. Basically, the Supreme Court had said that no action can be brought under the PMLA when one is absolved of the scheduled offences or criminal proceedings by a competent court. But according to the Madras High Court, this 2022 judgment of the Supreme Court should be read only in the context of what is decided in a particular case and not as a statute or overarching law. Speaking to ThePrint, Senior Advocate Vikas Pawa said that the High Court order contradicts established legal principles that distinguish jurisdictional police investigations of scheduled offences from the ED's role in probing money laundering, which is again a derivative offence dependent on the outcome of the scheduled offence. By treating money laundering as a standalone offence, the court has erroneously permitted the ED to challenge the scheduled offence investigation, effectively granting it the status of an aggrieved party, contrary to the precedent, he added. And with that, it's a wrap. For more legal updates, keep watching ThePrint.